My name is Avi Levy. I practice in Los Angeles County.
Hi, I'm Nathan Gabbard. I also practice in Los Angeles County.
Today we're going to be discussing what an RFO is, also known as a request for order.
What is an RFO?
I don't know, Nathan. Can you tell me?
Well, an RFO is necessary when you want to ask the judge to make orders in your case. A court's not going to move your case forward for you, so you have to actually ask the judge to do something.
What kind of orders can you ask for on an RFO?
You can ask for a wide range of topics in any request for order. You can ask for child custody issues, visitation, spousal support, child support, property requests, and any others.
Does an RFO end the case?
No, an RFO will not end the case. If you're filing a request for order before entry of a judgment, it can get you temporary orders. Or if you're filing an RFO after a judgment has been entered already, it can modify existing orders.
Well, does it cost any money to file an RFO?
It does. It costs a filing fee that you'll pay to the court, usually $60 for the filing fee, and the clerk at the court will ask you for that money at the time you present your paperwork.
Now, is there a reason why someone would need to file an RFO?
People generally file RFOs to ask the court to do something. So if you need something to change, or if you want orders to be put in place, then you'll make that request in paper. So Avi, tell me, once you've prepared your paperwork, the RFO paperwork, what do you do with it?
So what I would typically do is I would prepare all the paperwork, and the paperwork is pretty simple to prepare for us attorneys, but for people who are not attorneys, a little bit more complicated. So on the first page of the form, it's more of a check the box type of form. You would select what you want, whether it's child custody or visitation orders or support, whether it's spousal support, child support, attorney's fees, or any other types of orders. And the first page of the form then goes into what kinds, so if you're asking for spousal support, it will ask you, well, how much are you asking for? If you're asking for child support, it will ask you, well, how much are you asking for? If you're asking for custody of your child or children, it will say, what kind of custody are you asking for? So you fill all that out. And on the part of the RFO form, there's also a space where you could fill out why you're requesting these things. So if you want, for example, sole physical custody of your child, why do you want that? Give the court or the judge the facts that you think are important for them to know to make the orders that you are requesting. So that's what I would typically do. Sometimes there's not enough room on the form, and that's okay. What you can do is say, see attached, and then you can attach pieces of paper that can go into more of what you want the judge to know. You might have declarations from third-party witnesses that you might want to attach to your RFO forms. So when you get all that together, you go to the court and you file it. Now, filing is a little bit different. So you go to some courts have a filing window, but whatever courthouse you go to, you go to the courthouse, you file all your paperwork, and you have to typically pay a filing fee unless you have a fee waiver. And it depends on what county you're in as to how much that filing fee is. Sometimes there's an extra court reporter fee. Sometimes there's an extra fee if you're trying to modify a custody or visitation order. So it depends. And the clerk at the filing window will typically tell you how much you need to pay. Plan to pay anywhere between $60 to about $150 to file your RFO. And when you file your RFO, what that does is it gives the court a copy of your papers, and they stamp that paperwork on the very first page with the date that they've calendared for you to be in front of the judge.
Now, when filing a request for order, there are certain documents that you must present to the court. One particular form that you will need is the FL 300. This form is presented in a way that lays out in categories the types of requests that you can make to the court. Some of those types of issues we've already talked about. If you have a request of the court that doesn't fall within one of those specified categories, you can also mark the box for other relief. So if you're asking for something that's not already covered by one of the pre-made checkboxes, mark Other, and then write in section 8 the request that you're asking for. If your request has reasons that you want to tell the judge why you're asking for this relief, you can write that in the space near the bottom of the 4th page of the form. If you don't have enough room on that section, you can attach MC 025. That's basically a blank page that you can write on. Tell the court in your own words what it is you're asking for and why. This will help support your request. The judge needs to know the information about the circumstances surrounding your request, why it makes sense, why it's best, and that will give the judge the information they need to know to help you get the orders that you want.
There's also a really important form called an FL 150. It's Income and Expense Declaration. That form is required to be filled out completely and filed by you if you're filing an RFO that deals with any financial issues. So if you're filing for child support or spousal support or responding to someone else's RFO for one of those things, or asking for attorney's fees, pretty much anything financial, you're going to have to also file the FL 150 form. The FL 150 form is another 4-page form that asks you a lot of information that you fill out about your job, your income, your expenses, how much you've incurred in attorney's fees, how much you've paid in attorney's fees, what your custody schedule is, a lot of things that the court needs in order to make orders regarding child support or spousal support or attorney's fees.
Now, once you've received your papers back from the court clerk, stamped as filed, do you need to do anything else with the papers after that? What happens to them then?
Okay, so how does the other side know that you just did all this paperwork? So, and they need to know about the hearing as well. So,
If I'm the person filing the paperwork, can I give those papers to the other person?
no. So what is required is once you get the paperwork stamped by the court where it has the hearing date on it, now the other side needs to get that paperwork. They need to get a copy of everything that you filed with the court along with some blank forms. One of them is the FL 320, which is the responsive declaration to request for order. Another one is a blank 150 form. So again, if you're filing for anything financial related, you're gonna fill out your 150 form, but you have to give the other side a blank FL 150 form as well when you serve them. And the serving is really important. So it depends whether it is a post-judgment RFO or a pre-judgment RFO. So if you don't have your judgment yet, you're in pre-judgment RFO phase. You could typically serve somebody with an RFO by mail. There are certain exceptions to that, which we won't get into in this video. But you have somebody who's not you, who puts the paperwork in an envelope addressed to the other side, and then signs what's called a proof of service saying that they actually did that, okay? And there's timelines in how soon you have to do that, so it must be at least 16 court days plus 5 calendar days if you're going to serve an RFO by mail. That person must be over the age of 18 years old, not a party to the proceeding. So you're a party to the proceeding, it can't be you.
Now that I've been served with someone else's RFO, I need to respond to it, right, Avi?
Yes, so how do you do that?
Well, I bet there's another form, kind of like the FL 300, there's an FL 320. That form is necessary and required. The judge is going to look for that and see if you filed it. That's your response to the RFO. It's called a responsive declaration. This is where you get to directly address the request by the other side, tell your side of the story, and let the judge know why what you're asking for is better than what the other side is asking for. Now, if you agree to what the other side is asking for, you can simply say, I agree to that. But if you don't, you need to lay out very specifically, in your own words, why what the other side is asking for should not be ordered and what you're asking for should be ordered.
And again, when you fill out this paperwork, it has to be something that you personally observed, not something necessarily that somebody told you or that you didn't actually have personal knowledge of. What the judge is looking for, or the judicial officer is looking for, is how do you know this information? And that's what they want to know, because that's what they're reading. So if you put something in that form to say, oh, somebody told me that this person jumped off of a building, well, you don't know that, you weren't there, so you have to explain, I was there, I saw them jump, it was very scary, whatever the story is.
And once you've written out your story, your version of events on your responsive declaration, there are still rules about getting that responsive declaration to the other side. You do still have to serve that to the other party, and you have to do that 9 court days before the hearing.
And you could also, there's a few complications in terms of serving that. So again, you have to serve that. Nathan just said 9 court days before the hearing, but if you're serving it by mail, then you have to do it before the 9 court days. What typically is acceptable is if you serve it by Federal Express or other overnight service delivery, you could serve it on the 9th court day and it will be delivered to the other person the next business day, and that's acceptable.
So remember, if you need to ask a judge to make some orders, file an RFO. That's your request for order. Make sure you serve it on time, use the right forms, deliver it to the other side, and show up at your hearing. That's the way you get the court to make orders.
And typically the judge will have read your paperwork and the other side's paperwork before you even got there. And they're gonna ask some questions. You might have some questions that you might want answered as well. The other side, same thing. And then at the end of the hearing, the judge will make the order, whether it's the order you wanted, or the order the other side wanted, or an order that neither of you wanted, but something in the middle, or something that the judge feels that they should order because that's in the children's best interest, or that's the order that is based on the facts presented to him or her.
Because family law matters are so complex, there's no way to cover in just one video everything you'll need to know when filling out a request for order. But hopefully this video has helped you get on the right track.
Thank you.